What are some of the biggest mistakes that executors or administrators make in their roles as the personal representative of the estates? So, the personal representative has a fiduciary duty to act in the best interest of the estate, to protect the interests of creditors, and also to protect the interest of beneficiaries and heirs of the estate. The personal representative has to separate their personal feelings, their personal interests from that of the best interests of the estate. And often that's complicated for people to do. Some of the pitfalls that we commonly see with executors and administrators are failing to open an estate bank account. So if you have access to your loved one's bank account, that doesn't mean you can continue to operate within that bank account. Your duties and obligations as a personal representative requires you to obtain an EIN number for the estate and to set up a separate bank account. And that bank account is where you receive monies from closed bank accounts, the sale of property, or any other amounts of monies that come into the estate. They're all supposed to go to the estate bank account, and those funds are to be held separately from your own personal funds. Another pitfall that we see, and this is more with administrators and not executors, but with administrators, sometimes you're required to file an inventory with the court. If you are required to file an inventory, you have to do that within the first 60 days of being appointed. So you have to get a list of the items and assets in the estate, and you're going to use the appropriate probate form to fill out, include that information. You have to file it with the court. If you're required to do an inventory, you also have to get a bond. So you have to maintain the bond, and you usually are going to be required also to file an annual report that's due within 60 days of the anniversary date of your appointment. Another pitfall that we see is failing to secure estate property. And by that, I mean, if there's a house and someone's living in the house, the representative is required to have that person to vacate the house. The home needs to be secured. The personal belongings in the house needs to be secured as well. The personal representative should have all bank accounts closed and transfer those funds into the estate bank account. From there, any bills, mortgages, or taxes, or whatever else, or other expenses can be paid from that estate bank account, and a more detailed record of all the activity will be easy to provide to the court in the event that there's any question about your accounting or access to those funds. Another issue that I see an easy trap to fall into is distributing estate assets too early. Under Georgia law, you have to give creditors an opportunity to come forward. You're going to file a notice to debtors and creditors in the county newspaper. That's going to run for 4 weeks. Then those creditors are going to, as best practices is to give them about 4 months or so to come forward. Once the creditors come forward, all claims have to be resolved from the estate assets. And only after those claims have been resolved can you distribute property to the heirs. Oftentimes we see administrators or executives immediately accessing estate funds and dispersing it either to themselves and or to the other heirs and beneficiaries to the exclusion of the creditors. And that's just a recipe for personal liability or some type of lawsuit being brought against you as the administrator or executor of the estate. The last few issues that I see kind of related, they're again failing to file the notice to debtors and creditors and failing to keep proper records. So these two typically go hand in hand. When you're not keeping records, you're not staying on top of the estate, you're not fulfilling your obligation to creditors. You are fulfilling your obligation to creditors, then you typically are going to see those people also keeping up with really good records of the transactions of what's being dispersed out and what's being received into the estate. But either way, If you're an administrator or you're an executor, you should have a record of what's coming into the estate and what's going out in the event that anyone wants to question whether you're administering your duties properly. The last issue is failing to seek legal help. In some instances, particularly if they're businesses, their rental properties, their outstanding taxes, their large debts against the estate, there's money that's owed to the estate. You may have a specialty items such as boats or personal aircraft. In those instances, you do need to seek legal help and allow your legal help, your attorney, to also secure other professionals that will be needed as well, such as accountants or persons who can properly value assets. You can prepare for those assets to be either transferred or sold and dispersed according to the will or dispersed according to Georgia law.